Based on the shortened Oxford English Dictionary, domicile means the place of residence or ordinary habitation, a house or a home, the place where one, which has his permanent residence, to which, if absent, he has the intention of returning. There are four types of domicile, which is domicile of origin, domicile of choice, domicile of dependence, and matrimonial domicile. Malaysia, however, does not apply the concept of matrimonial domicile, while it is applied on England.
The first issue is whether the court has jurisdiction to hear Marimutu's petition for divorce. According to Section 3(1) of the LRA, this Act shall apply to all persons in Malaysia and to all persons domiciled in Malaysia but are resident outside Malaysia. Next, does Marimutu acquire a domicile of choice in Malaysia? For his petition to fall under the jurisdiction of High Court, he needs to prove he changed his domicile of original from Bangladesh to Malaysia. According to Section 48, subsection 1C, where the domicile of parties to the marriage at the time when the petition is presented is in Malaysia. In the case of Sheikh Abdul Latif and Sheikh Elias Bucks deceased, was domiciled in Hong Kong. Later he moved to KL. He amassed wealth and considered Kuala Lumpur as his residence. Meanwhile, his wife's never been to Hong Kong and he had no property there. Therefore, the court held that he acquired domicile of choice in Malaysia. Same goes in the case of Marimutu. He took 1 year leave to go back to Bangladesh and get married with his wife. Let's say he brought his wife here to work in Malaysia, raised his family in Malaysia by sending his children to school in Kuala Lumpur, and his children never been to Bangladesh. This shows the intention of him to stay in Malaysia permanently. Based on the facts of the present situation, it can be said that Marimutu had acquired a domicile of choice here in Malaysia, and his wife Karina Kapoor eventually takes on the domicile of Marimutu upon marriage, and it will remain that way as long as they remain married. Therefore, both the parties to the marriage are domiciled in Malaysia. As a result, Marimutu may apply for a petition for divorce in the High Court.
The second issue which would arise if Marimutu were to set up a company in Bangladesh during his stay there in 2015 is whether he had lost his domicile of choice in Malaysia as state in question. As had been explained earlier, a person's domicile of origin is suspended upon acquirement of domicile of choice, but will be revived upon relinquishment of his domicile of choice. In a simple word, Marimutu's domicile of origin will revive upon termination of his domicile of choice in Malaysia. The question to be asked is whether his act of setting up a company in Bangladesh conveys an intention to terminate his domicile of choice. An example in the case of Joseph Wang Puilan and Yoh Lung Goit, where the relevant facts were that the petitioner husband and had built an audit practice in Singapore and only returned to his matrimonial home once or twice a week. The issue in this case was whether the petitioner had acquired a change in his domicile from Malaysia to Singapore. It was held that there was a change in the domicile because besides setting up the practice, he had also married his mistress there and had children with her. This showed clearly evidence that there was a strong intention for him to change his domicile from domicile of origin in Malaysia into domicile of choice in Singapore. Therefore, the court in Singapore had jurisdiction over his petition of divorce. Relating the case to Marimutu's situation, it could not be said that Marimutu intends to terminate his domicile of choice merely because he had set up a company in Bangladesh during his 1 year stay there. Other than that, he had done nothing to represent such an intention. Furthermore, a company can be managed even from another country where he could hire people to work and manage his company in Bangladesh. In conclusion, even he has set up a company in Bangladesh during his stay, the High Court will still have jurisdiction to hear the petition because there simply isn't enough evidence to show that he had abandoned his domicile of choice in Malaysia.